This video drops you straight into a tense courtroom showdown where reality collides with belief. A man identifying himself as a sovereign citizen stands before the judge, but instead of addressing the charges in a normal way, he challenges the very authority of the court itself. From the very first moments, he refuses to properly identify himself and insists he was traveling, not driving, claiming that the laws requiring a driver's license don't apply to him. The judge, calm but clearly experienced with these tactics, wastes no time shutting that down. As the hearing unfolds, it becomes clear this isn't the defendant's first run-in with the system. The court brings up his history of missing court dates and ignoring prior orders, raising serious concerns about whether he'll follow any rules if released again. That history plays a major role when the judge discusses bond, ultimately setting strict conditions designed to keep the public safe and ensure he actually returns to court. But instead of acknowledging the situation, the defendant continues to argue technicalities, word games, and fringe legal theories. You'll hear him carefully say, "I heard you," instead of, "I understand," question the judge's oath, and suggest the court has no real power over him. Each time, the judge refuses to get dragged into side debates and keeps pulling the focus back to the law and the charges at hand. The contrast is striking, one side grounded in established legal procedure, the other clinging to internet-style legal myths. By the end, what you're watching isn't just a routine hearing, it's a real-time example of how these courtroom strategies play out when tested against an actual judge. It's tense, frustrating, and eye-opening all at once, showing exactly what happens when personal ideology runs headfirst into the legal system.
State your full name, Mr. Durham.
Renzo of the family Durham.
Here. For waive formal reading under a plea of not guilty. Mr. Durham, the court scheduling a pretrial date on this matter via Zoom. You must attend February the 27th, 8:30 a.m., 36th District Court in front of Judge Bryant. Understood?
I hear you.
And this is a very serious non-assaultive allegation, Mr. Durham, and the court has concerns that you missed a court date on this matter, as well as two other matters that we're about to handle. And your capious history, Mr. Durham, tells the court you do not listen to the court as ordered to appear, and that's concerning where if the court were to release you on another personal bond, sir, you treat it as you have in the past and disregard court's orders and simply not appear. And that's unacceptable, Mr. Durham. You must appear as ordered. So the court, based on your capious history, taking into consideration the information presented by counsel, including that limit to employment status as relates to the ability to post bond, the nature of the charge, as well as the information alleged in the investigator's report, is setting, based on your capious history, is going to continue the bond set by Judge Bryant of 110%. Is that an affordable bond?
It's not.
Okay, so on that matter, the court is setting an unaffordable bond redetermination hearing. During this bond, you are not to purchase or possess a firearm or any dangerous weapon, and you are not to drive any motor vehicle unless you have a valid driver's license. Is that understood?
I don't drive, Your Honor. I travel. I'm not driving ever again in life. I travel, so I don't need a license to travel.
Well, yes, you do, Mr. Durham. There's no traveling behind a motor vehicle. I'm not arguing with you, Mr. Durham. I'm telling. Excuse me?
I've already read the Supreme Court case law. I have a right to travel, sir.
Okay, well, I have a right to impose bond and conditions of bond, Mr. Durham, and I'm telling you, whether you call it traveling or driving, there's to be none of that behind a motor vehicle. You're not to travel if you're operating a motor vehicle or drive. No driving or operating of a motor vehicle, regardless of what you call it. Understood, Mr. Durham? No driving or traveling if you're the operator. Is that clear? And you're not to leave the state of Michigan. Is that understood?
All right.
Period. That's regardless of your license status. There's to be absolutely no driving or traveling. Okay, I said no traveling either.
Driving is up.
No traveling. Just put that as a bond. No traveling.
So that means I can't even go to court if I can't travel. I can't leave my house.
It's via Zoom. It's via Zoom. It's via Zoom. No traveling. The court dates are via Zoom. No traveling unless court ordered.
That's a violation of my rights. and I will appeal this in a higher court.
Did you want to address his traveling, counsel?
I'm sorry.
Did you want to address his argument that he can't, that he can travel?
He's going to comply with court orders.
And that means no driving and no traveling. Is that correct, counsel? No traveling unless court ordered. Yes, I can't leave the state of Michigan, and he cannot. Would he drive or travel? Which my understanding is him operating any motor vehicles. That understood? Thank you. Okay, Mr. Durham, this is a very serious allegations. Again, you have a capious history on this matter. The bond was set by the judge when you failed to appear. You have a number of capious histories on this matter. It looks like you were originally given a personal bond, then you failed to appear on about September 1st of 2022, given a 10,000 cash surety, and then you failed to appear again December 14th of 2022, and then a judge will give you another 10,000 cash surety. I, as a magistrate, as counsel stated, have no. One moment, I'll let you address the court. One moment, Mr. Durham. Have no authority to amend the capious bond as set by the judge for your failure to appear. So for that reason, the bond is going to be continued as set by the judge of December 14, 2022 in the amount of $10,000 cash surety. During this bond, you are not to purchase or possess a firearm or any other dangerous weapon. No driving, no traveling unless court ordered. You will be fit with the GPS tether under house arrest if you're able to make bond. And no use of any alcohol or illegal controlled substance. Is there anything further, counsel?
I would respectfully ask the court to reconsider the GPS tether, Your Honor.
He's missed court in every matter before the court this morning, so no.
Thank you.
You're welcome.
No, I haven't.
Anything?
I done came to court a couple times on Zoom, on a tether. I done been to court.
But not all of the times it does not appear, Mr. Durham. It looks like you've missed court more than once on that matter that we just handled. Anything else on this matter, counsel?
On account of the county jail. I missed court on account of the county jail. They wouldn't take me to court. I missed court because of the county jail would not take me to court. That's not.
The court has the same concerns, sir, that you've had a capious on this matter as well as the matters before the court previously, and that demonstrates to the court that you failed to appear as ordered, and that's concerning regarding your intention to appear and handle this matter. It looks like you're on a personal bond by the Honorable Magistrate Ramsey Heath, where you failed to appear on or about December 14th, 2022, and a bond was issued at 10,000 cash surety. I, as a magistrate, have no authority to change that bond as set by the judge. So the bond is going to be continued, taking into consideration any employment status presented by counsel as it relates to ability to post bond, as well as your capious history. During this bond, no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any other dangerous weapon. If you're able to make bond, you will be under house arrest, fit with a GPS tether prior to release. There's to be no driving and no traveling unless court ordered. Okay, any questions or statements, Mr. Durham? You are being recorded. Anything you say can and will be used against you. And on that matter as well, you're getting an unaffordable bond redetermination hearing on January the 19th, 2023. Judge Sabri at the 36th District Court via Zoom. Do you have any questions or statements, Mr. Durham?
Yes, I do. This question is to you, the magistrate. Are you honoring your oath?
Before you say anything,
This is your turn.
everything you say right now kind of will be live or on YouTube. Please do not say anything right here. I would like to actually, because I try to protect you, okay?
That was your attorney speaking and giving you advice.
Are you honoring your oath, sir?
I don't know what type of question that is, Mr.
Now you don't know what it means. You took an oath to uphold the Constitution, didn't you? Are you honoring
I don't
your
know
oath?
what the purpose. I don't know what the purpose. I'm not here to answer your questions. I can tell you that, Mr. Durham, as far as regarding questions that don't have anything to do with the arraignment. I'm not here to just answer random general questions that have nothing to do with your arraignment, Mr. Durham. So if you have any questions regarding your arraignment or your court date, you can please let me know.
I want to know who you are. You won't tell me your name. You won't tell me if you're bonded. You're a public official. Are you bonded?
Mr. Durham, I'm not going through it. Mr. Durham, I'm not going through that, the nature of my employment.
You got to give me your bonding information, name, address, and your policy number so I can make sure you're adequately insured. Just in case you want to violate my rights, I got to make sure you're adequately insured. Are you a public official and are you insured?
My name is Chief Magistrate Jeffrey Courtroom. I've answered that question regarding binding, Mr. Durham. That's not something that's going to be addressed today.
So you're not going to put that on the record?
I'm just not entertaining a question that makes no sense during the arraignment, sir.
It makes no sense to ask you if you're bonded. And what's your bonding
If
information?
this
That
makes
don't
you
make no
happy,
sense.
Mr. Durham. I'm bonded if that makes you happy, Mr. Durham. I do have a valid, as indicated by statute. Mr. Durham, I'm not getting back and forth. Counsel, do you have anything further with Mr. Durham?
How about the number of the bonding company? Can I have any of that so I can contact them? I got to be able to contact them.
No, Mr. Durham, I'm not. I gave you, I let you know I was bonded. My name is Chief Magistrate Coperic at the 36th District Court. That's the information. Okay, Counsel, we can try anything further. Mr. Durham, I've said more than once, we're not going through that here today on the record. So, Mr. Durham, if you have any questions about your arraignment or court date, otherwise, we're through with the arraignment. Counsel, do you have anything further?
To give me the name of the bonding company.
Unless you have anything else, Mr. Durham, we're through with the arraignment.
Amazing.
This courtroom hearing unfolds like a slow-building confrontation between two completely different understandings of how the world works. The setting is formal, controlled, and structured, but the tension is obvious from the very beginning. A man stands before the court facing legal issues tied to operating a motor vehicle, yet instead of addressing the situation in a conventional way, he challenges the foundation of the court's authority itself. What follows is not loud or chaotic, but it is deeply intense, a back and forth that shows exactly what happens when personal ideology runs straight into established law. As the proceeding begins, the defendant signals immediately that he does not intend to participate in the way the court expects. Basic questions that would normally take seconds to answer turn into drawn-out exchanges. He avoids clearly identifying himself and resists acknowledging the court's jurisdiction over him. His tone suggests he believes he is standing outside the legal framework everyone else is bound by. Rather than engaging with the charges directly, he focuses on language, definitions, and technical interpretations that he believes change the entire situation. One of his central claims revolves around the distinction between traveling and driving. He suggests that he was merely exercising a personal right to travel, not engaging in a regulated activity that requires a license. To him, the words matter so much that they redefine reality. But the court views the matter very differently. The judge, composed and matter of fact, makes it clear that operating a motor vehicle on public roads is subject to state law, regardless of the label someone chooses to apply. The exchange highlights a fundamental divide. One side arguing from personal interpretation, the other from written law and precedent. As the conversation continues, the judge brings up the defendant's past interactions with the court system. This is not an isolated event. There is a record of missed court dates and prior orders that were not followed. That history changes the tone of the hearing. Courts rely on compliance, on people showing up when they're told and following release conditions. When someone repeatedly fails to do that, trust erodes. You can hear that concern in the judge's voice as he explains why the court must take a more cautious approach this time. The issue of bond becomes a major focus. Bond is not just about money. It is about balancing an individual's freedom with the need to ensure they return to court and do not pose a risk. Because of the defendant's history, the court sets a bond that reflects the concern that he may not voluntarily come back. Along with that, strict conditions are laid out. He is not to possess firearms. He is not to operate a motor vehicle without a valid license. He is not to leave the state. Each condition is direct, clear, and legally grounded. Instead of acknowledging the seriousness of these orders, the defendant continues to focus on wording. He carefully says, "I heard you," rather than, "I understand." To most people, those phrases mean nearly the same thing, but here the choice is deliberate. Some believe that avoiding certain words creates a kind of legal shield or preserves an argument for later. The judge appears fully aware of this tactic and does not get distracted. He calmly repeats the conditions and makes sure the record reflects that the defendant was clearly informed. The hearing then shifts into another familiar area of challenge. The defendant begins questioning the judge's authority on a personal level. He asks about the judge's oath of office and whether the judge is bonded. The implication is that unless these questions are answered in a specific way, the court's authority is somehow invalid. But the judge refuses to go down that path. He explains that those questions are not relevant to the matter at hand. The court is there to address the charges, the bond, and the legal process, not to debate abstract theories about government legitimacy. Throughout the exchange, there is a noticeable contrast in approach. The defendant speaks as though he is engaged in a philosophical or semantic debate, trying to find a gap in the system through language. The judge, on the other hand, keeps everything grounded in procedure. He returns again and again to the same core points. The charges exist, the court has jurisdiction, and there are specific rules that must be followed. The repetition is not accidental. It ensures clarity and creates a record that leaves little room for misunderstanding. At one point, responsibility becomes a key theme. The defendant suggests that outside factors, including time spent in jail, played a role in his failure to appear in court previously. But from the court's perspective, accountability still rests with him. Legal systems are built on the idea that individuals are responsible for complying with court orders, regardless of personal beliefs or grievances. That principle sits quietly underneath the entire hearing, shaping every decision the judge makes. The longer the exchange goes on, the clearer the dynamic becomes. The defendant is trying to assert independence from the system while physically standing inside it, subject to its rules. The judge is not attempting to win an argument, he is carrying out a process. That difference in goals creates a kind of stalemate in conversation, but not in outcome. The court's decisions still stand. Orders are issued. Conditions are set. The case moves forward. What makes this moment so compelling is not raised voices or dramatic outbursts, but the steady, almost clinical way the system responds. The judge does not mock the defendant's beliefs, nor does he validate them. He simply does not treat them as legally meaningful. That quiet refusal to engage with fringe arguments is, in itself, a powerful statement about how courts operate. The legal system is built on statutes, case law, and procedure, not on personal declarations of sovereignty. By the time the hearing draws to a close, the lines are clearly drawn. The defendant maintains his position that the system should not apply to him. The court maintains that it does. No breakthrough occurs, no dramatic change of heart, but something important is shown in real time. Belief does not override law in a courtroom. The process continues whether someone agrees with it or not. This hearing becomes more than just one person's case. It turns into a window into how courts handle challenges to their authority. Calm repetition, focus on the relevant issues, and firm but controlled enforcement of rules. The tension never explodes, but it never disappears either. It lingers in every exchange, a reminder that the courtroom is a place where ideas are tested against legal reality, and legal reality is what ultimately decides what happens next.